And so I want to turn it over to Commissioner Professor Kieff.
What a pleasure to be back among so many friends and in person among so many friends. And it's, of course, a pleasure to have folks online as well. And just thank you all for organizing. The organizers of this event have done an incredible job under difficult circumstances. This is co-authored work with an old friend, Tom Grant, and we hope you find it to be useful or enjoyable or a little bit of both. So we've collaborated a lot over the years, a lot of years and a lot of distance, various parts of the world, academia, private sector, public sector, and with various governments as well. My kind of work map is a little helter-skelter. It's a little bit of everything, but it's really a lot of technology and law and markets with angles on security and IP and trade. And Tom's is really pretty similar. A lot of international work and multinational work, but again, with a fairly heavy focus on technology and markets. And we all, I think, are pretty familiar with why IoT and why 5G, what they're about, at least the folks in this room and the folks, I hope, online who have had a chance to listen to some of the other speakers. So let me just briefly flag, why do we care about this? Because we care about the future. This is a lot of stuff we're going to use in the future. Why do we care about the future? Well, that's at least where I plan to spend the rest of my life. Charles Kettering made that point. Why do we care what Charles Kettering has to say? First, what a funny guy. Second of all, what a great contributor to worldwide innovation and competition. And third of all, he plays a pretty featured role personally in this story. All of the ideas I'm going to talk about here are ideas I've gotten from many of you, friends, former prior co-authors, and for those of you who just like it short and sweet, these are some pretty short online versions of some of these ideas if you're interested. I think a lot of us are familiar with this tension at the intellectual property antitrust interface, the idea that you want to move forward, and yet I think, to be fair, the central criticism of intellectual property in general and patents in particular is that folks call it a rat with good PR or a squirrel. I mean, what's the difference? The squirrel has the bushy tail, but it's still basically like a rat. I think a lot of people see IP as just a rat with good PR. I get that critique. I understand it. Lord Justice Robin Jacob, another former government person who's been in academia now for a little while, he's got a great sense of humor. I'm not sure I agree with him, though. So the popular view, we all know the popular view, patents are going to kill us, right? The world's going to stop spinning on its axis. Cats and dogs will live together. Patent enforcement's going to do it all. It's going to ruin everything. I get the view. I understand it. Certainly, we all know it. And Research in Motion did an amazing job pumping its brand in the early days of Davos by handing out BlackBerries to the cool kids, and then everybody wanted the BlackBerry, and the BlackBerry was so vital to society that if you shut down the BlackBerry, society would get shut down. We talked a little bit this morning about the market for corporate control. What I think is interesting about the BlackBerry case, an early in these debates case, is that people talk about how it's settled for $600 million, and golly gee, what a lot of money. And that is a lot of money. Here at George Mason University, we're a public university, we would only pay our faculty members a little less than $600 million for teaching a course. I get it, $600 million's a lot, but you start to look at the context of the case, and suddenly a lot melts away. So the first thing to notice is all of the public information about the early negotiations in that case is that the early offers were around 4, 5, 6 million, 1/100th of the settled price. And one response to that is to say, well, then maybe the implementer made a mistake by waiting so long to settle. They had to pay 100 times what they were offered early in the case. But another response is to notice that the public estimate of the case was $1 billion, which is 2x. And okay, maybe the public is ill-informed, maybe the market hypes stock too much. But then you might ask the infringer, what was their private, internal, subjective evaluation of what they thought they might lose in the case? And turns out we know what they thought because they were a publicly traded Canadian company. And so under the disclosure rules of their stock exchange, they disclosed to their shareholders, please keep investing in us. If we lose this case, we'll still be profitable. And you, as our shareholders, should believe us because we've set aside a pot of money to pay the lawsuit and show you that we're still profitable. Well, how much had they set aside? $1.8 billion, 3x. So suddenly, they look like rock stars. They look like dragon slayers. They faced a $1.8 billion liability, and they settled out for a third of that, $600 million. Now, they're ahead of the curve. They're early risers. They got the worm. So, in fact, the market for corporate control, if you take apart the numbers and look at what it would have taken to do an LBO, a leveraged buyout, typical way, and by the way, to get control of a company, you don't need all of the public float, but you could have bought the whole public float of the company. You could have paid a typical premium in the stock market, and then you could have settled the case at the stock price that, in fact, the company stock went back to the day the case was settled, and you would have made a 40% return on investment. 40% return on investment. You understand that in the modern world, we're debating interest rates. Sky is going to fall because interest rates are going to go to 7 or 8%. This is 40% in just a couple of months. That's a great return. So then we hear that the real problem with patents, the central problem with patents, is that this is invisible stuff. You don't touch a patent. And so I can, walk around the stage and not bump into anything. But boy, if there's a patent, I just run right into that sucker. And it really hurts. It's embarrassing. Oops. And, I bump my nose, I get a bloody nose, and I'm going to get shaken down. I have no idea where these crazy property rights are. But a few things to notice about most of the famous cases that are discussed as examples of notice failure. One, it's not an accident that patent law has all these rules about giving notice, the so-called Section 112 disclosure rules. And these are all cases where the entire court system, the trial court, the appellate court, even when they get all the way up to the Supreme Court, these are cases that are infringement cases. There was infringement, which means we already litigated to the death validity, and we decided the patents actually were valid, which meant they satisfied the objective disclosure requirements. So, I don't know what I didn't see it includes, but I think it probably shouldn't include, but it was visible enough to satisfy the disclosure requirements. After all, that's why we have the disclosure requirements, to give notice. Now look, maybe our disclosure requirements aren't where they should be. Maybe we should ratchet them up a little bit, or down a little bit, or sideways, or a little chocolate, a little less vanilla. Fine, let's adjust our disclosure requirements. But then let's ask the separate question. What about subjective surprise? Remember Casablanca? I'm surprised there's gambling going on here. Well, I don't know what surprise means if it includes my lawyer said it would happen. These were willful infringement cases. These were cases where the lawyer of the infringer said, you're gonna hit your head. That's where the property boundary is. So what we should notice in these debates is that we're getting quite deliciously elegant in ignoring the objective rules of disclosure, and the subjective, did the person even know where they were going? Well, they did know where they were going. Their lawyer said, you're gonna bump your head, you're gonna trespass. I think as we start to think about context, how do human beings interact? How often do human beings interact with each other where they just hold out or hold up? There are a lot of examples in life. First of all, in repeat games, if you and I are interacting with each other a fair amount, we have lots of incentives not to treat each other that badly. But second of all, for those of you, this is not the right time of year in Washington to be going out on your sailboat or on your rowboat. It's starting to get cold. This is almost winter, at least for DC. That means it's like, you have to put on more than a t-shirt. So, okay, fine, it's cold. You're not going to go to the beach. You're not going to go to the dock. But for anyone out there who's learned about life on a dock, have you ever met someone who's grown up on a dock and been taught that the thing you do at the dock when someone's trying to tie their boat up at the dock is kick them away? No one learns that. Across gender, across race, across geography, there's this incredible norm about docks, which is if someone's kind of getting near the dock, you say, hey, bub, throw me a line. I'll pull you in. I'll pull you right in. There are some extremely rare examples of people pushing someone away from the dock. Plouffe against Putnam is a case we all learn about in first-year property law. What makes the person push the boat off the dock? Well, for those who like movies, it's The Princess Bride, the dread pirate Roberts. This happens to be a real pirate. When the pirate's coming up to your dock, and it's a pirate you recognize because they've been marauding up and down Lake Champlain, okay, that's the one you push off. But wait a minute, there's a lot of context to that. And that context is not, I'm a troll, that context is, you're a pirate. Those are very different contexts. Sure, patents and antitrust, they get close, but they're not as close as a lot of people think. Remember, a patent is on a particular product, a particular service, a particular device. I get a patent on the glue mousetrap or the spring mousetrap. Someone else comes to market with glue mousetraps or spring mousetraps. And just remember, the real market is mice abatement, and that means cats are in that market too, right? So for those of us who are really economics oriented, this is all about the deadweight loss triangle. This is absent a deadweight loss triangle. Monopoly, when thrown around in these settings, is an epithet, not a reality. Okay, not always. Sometimes it's in fact advertising. But I don't know what we get with the rhetoric of either calling it awesome or terrible. Awesome, by the way, I love playing the game. Terrible, you patent monopolist. But I do think it's got to get past the rhetoric. In the US, the patent antitrust interface has fluctuated a lot. We are in a system right now that we all recognize. We've been in it before. We were in it in the early 1900s. We were in it again in the 1970s, but we also have been out of it many times. And what's worth noticing is we've been in and out of it under political parties of opposite sides of the political aisle, both. There are Democrats and Republicans who have been anti-patent, Democrats and Republicans who have been pro-patent. I like these three folks. I grew up on the south side of Chicago. My mom actually taught at Hyde Park High for a little while. He went to Hyde Park High. He became a judge in New York. Well, he went to New York, became a judge, became chair of the Securities and Exchange Commission. Here's another one. Law students have all learned about that one, the learned hand rule. And then patent students all know the guy on the right, Giles Rich. A self-described progressive Democrat, a self-described centrist Democrat, an Eisenhower Republican. What do the three of them have in common? The approach to patents in the blue, not in the red. And my suggestion here is let's choose blue, not red. And not because of political party. We've seen this before. We've seen it when we think about enforcement of patents, and we've seen this when we think about enforcement of contracts around patents. IoT, 5G, what is really going on in these markets? A vast amount of combining, which means transacting, which means negotiating with and negotiating around, what economists might call private ordering. But all of that interactivity means you have to have a legal framework for analyzing the interactivity. And in the late 1800s, early 1900s, we got ourselves a little sloppy, and we went, I think, too far for IP, and then we went too far the other way, anti-IP. But what I think is really the problem with these two is not just that they're too far, it's how they got too far, one way or the other. And in effect, what they did is they stopped applying the detailed legal rules, and they got into a lot of hand-waving and rhetoric. What did Congress do? Congress knew this. Congress recognized this. It did a number of things. It wrote the 1952 Patent Act, passed it, the president signed it. But the 1952 Patent Act did a lot on purpose, really explicit. It came up with different words, different legal tools for talking about obviousness. There's nothing special about the word obviousness. What's special about the word obviousness is it's different than the old word, the requirement for invention. It was designed to jettison the case law. It picked a different word for patentable subject matter. It wrote 101. It talked about contributory infringement and inducement of infringement, all of these contractual arrangements around the patent. And in the words of Jerome Frank, that man from the South Side, that's what made David beat Goliath. So when David comes to market against Goliath, this kind of predictable enforcement of patents using the actual legal rules rather than the hand-waving, it doesn't always favor patentees. It doesn't always hurt patentees. What it is predictable, and that predictability lets the market work. It lets the market work in a way that helps big companies, but not only big companies. It lets the market work in a way that also helps little companies. And it's pretty detailed. For the lawyers in the room, there were specific changes in the statute. And the changes were pretty vociferous. They were explicit. In addition, for example, to Section 103 on non-obviousness, there's Section 271, which goes so far as to say this is patent infringement, and by the way, this is not misuse. This is patent infringement, and this is helping other people infringe, and by the way, neither of those is misuse. And what's interesting about this is it takes until the 1980 Dawson decision, about 30 years, before the Supreme Court, by the way, says everything I just said back to you. It says, let's go look at the legislative history, let's see the debates, let's see what was happening before the 52 Act, and let's ask, why are we going to use this new statute? What is it designed to do? And in that debate, it is also worth noticing all of the same facts we see in today's debates. I mean, after all, that case happened to involve farmers. Farmers are a sympathetic audience. You get an interesting mix of the so-called left and the right. The left, farmers feed us all. The right, farmers are often Republicans. Not always, but they often these days own land. And that tends to create a bit of a voting bloc. The patent issued after the patent was filed, well, that turns out to be normal. But in the debate in the case, the reason that normal gets ignored is that one side of the debate says, I was doing my activity and I ran into the patent. But I started doing my activity before I even noticed the patent. That's sympathetic, but it was after the patentee invented. And that's the key. So the patent's validity is not determined by whether the infringer knew about it, And the patent enforcement is not determined by whether the infringer knew about it. Also, by the way, what's I think interesting about that particular case is there's a straightforward explicit dissent. And one of the dissents, this happens to be Justice White's dissent, is, yeah, but why would you follow the statute? I mean, he just straightforwardly says, I understand that's what the statute says. I understand that's why the statute was written, but I disagree on a policy level. Well, that's an interesting move to make these days. So I am not saying get rid of antitrust. There's lots of room for antitrust. There's regular antitrust where there's market power, and there's antitrust where there's sham litigation. There's plenty of room for antitrust. This is not a patents über alles discussion. It's a discussion that says, isn't there a little room for both? So what is the thinking here? What's the basic philosophy? How's this going to work? Well, this relates to how you can think about property rights generally, which is that when you think about property rights generally, it's not about how many of them you have, and it's not about just how strongly you enforce them. The Caribbean basin during the Atlantic slave trade had lots of property rights that were enforced with a lot of violence, and we are generally in agreement that that was a bad thing. This is not about numbers and strength of enforcement. This is about the predictability of the enforcement, the ability for those in the marketplace to transact over the enforcement. Because if instead you structure these rules in a way in which the only transactions that work are the transactions that are shunted through a government official, well then the only thing you're strengthening is the people who have better access to government, who will always be the large established players. That's because they're large and established. So how do we think about patents? Most people talk about patents as tools for providing an incentive for the inventor to invent. And I think that's a nice story, but it doesn't work. I think patents do something else that's close to that story, but much more helpful and much less pernicious. What is it? You turn out all the lights in this room, there are no windows, it becomes pitch black. One of you turns on your flashlight. What do all the rest of us know? Exactly where you are. A patent that is enforced with predictable rules can be like a beacon in the dark and can draw to itself all of the many complementary users of that asset. And it says nothing about who controls the bargaining power in that discussion. Maybe it's the person who's the venture capitalist who brings the money. Maybe it's the person who has the other invention that's really more valuable. Maybe it's the manager who's just great at marshaling a team. Maybe it's the union that brings a coordinated workforce. Who will control that negotiation? We don't need to know, so long as we know there's predictable enforcement of the patent. The beacon in the dark is what we are trying to create. The D part of the R&D, the development, not the inventing part. The inventing part turns out really hard to do. I am not suggesting that we want to discourage it. I am explaining that it is hard to directly target. And therefore, we should target what we can target, which is once an inventor announces to the world where she is, she files her patent application, we should protect her, because that will help all of us. We like her, we're not out to hurt her, but it's not that we are rewarding her, we are rewarding all of us. The rhetoric in this space is intense. And it is about death, life and death. You enforce patents, people die. But you start to peel back the rhetoric, and it's not clear that it adds up, in part because it's not clear that essay is patent infringement, and it's not clear, even if it is patent infringement, what's wrong with it being patent infringement. Remember, think about real estate. There are lots of plots of land that don't have fences and don't have people with guns running around shooting everyone who walks or steps over the line, because the cost of enforcement to the owners is very high. not just the cost of enforcement to the user. Under enforcement in an optimal way happens a lot with land. It happens a lot with stuff. You're not using that, can I borrow it for a minute? You're not using it, I don't ask to borrow it, but I go ahead and borrow it. There's a lot of that interaction that happens in the world with tangible and intangible. How do we know this? Well, here's a great example. Before the 1980s, US, Europe, and Japan all basically had no effective enforcement for patents in biotechnology. And after the 1980s, only the United States did. And what happened? Well, we all had large pharmaceutical companies, and we all still have large pharmaceutical companies. The central difference, only in the United States, only after 1980, do you see a large growth in small and medium-sized enterprises in addition to large pharmaceutical companies. Hyperproliferation of firm size and radical increase in the number of new drugs and new devices brought to market worldwide, and with little practical impact on access or price for the poor, even in the developing world. So what is the benefit here? The central benefit here is all of these other parties get to transact around these assets. And this, no significant need for individual government agencies or government officials or judges to titrate up or down the exact right amount of the value each of you may have added to that coordination dance. What do we, the government, have to do in those settings? Enforce the property rights and the contracts on their own terms. So what's happening then? Why might large firms want patents if they're generally against this story of patent enforcement? Well, think about they're shifting the patent system to what people often call a weak or less predictable or more discretionary enforcement system. It's a system that tilts the playing field in a way that helps large companies in a different way and stops, it cuts off the oxygen for the small and medium-sized companies. Why? What can a big company do with a patent portfolio of, I don't know, 1,000 or several hundred relatively low-value patents? It can transact. With whom does it transact? Lots of government agencies. Just imagine you're a safety regulator in the government. Just imagine you're a health regulator in the government or an antitrust regulator in the government. What are you expert at? That thing, whatever that regulation was you're doing. So imagine you say to a Xerox, hey, you're caught, or an IBM, you're caught in a big antitrust problem right now. And the defendant in the antitrust case says, I cry uncle, I'll settle with you, the government. But then the regulator, who's an expert at whatever they're regulating, and the company have to settle. And that settlement probably does not include shutting the company down, because that puts lots of people out of work and stops customers from getting access to stuff. So they let the company stay in operation. And then the company says to the regulator, but I'm going to be a good boy now. I'm not going to do whatever bad thing I did that led to this investigation. Let me go forward, and let me earn money as I go forward. And I want you to trust me that I'm good. I want you to let me price to the extent I add new stuff into society. Maybe a penny for every new thing I add. And then the regulator says, but how are we going to count that? And the company says, it's funny you asked that question. I've got a handy answer. How about for every patent those folks in the US Patent Office give me, you decide that's a measure of how much I've just added to society. Great. They settle the case. Everyone's happy. What has not happened? Well, the Patent Office is not designed, not able to do a thorough evaluation of patent validity. It's designed to do a rough first cut. The folks who really figure out patent validity and patent infringement are all of you, the folks involved in advising companies, litigating, fighting, negotiating. So what you get in these settlements with various regulators of antitrust, of food and drug, of environment, of safety, what you get is no one in the game is actually paying attention to the substance of the patent. You're just counting patents and pricing. Well, that's a great way to get it wrong because it's not designed to get it right. And why would those same big companies love patent litigation? Well, patent litigation can help them. It can help them do the kind of antitrust stuff that we all agree is an antitrust problem, which is large firms coordinating with each other to divide up the market. If I make automobiles and you make automobiles and we're the two large automobile manufacturers, well, we might want to agree with each other. Hey, I'll make large cars, you make light trucks. Hey, I'll cover the East Coast, you cover the West Coast. But if we pick up the phone and have that conversation with each other, we have two problems. Problem number one, we hate each other. We're competitors. Why are you going to trust me? Problem number two, it's a criminal antitrust violation. So we have our trust problem and we have our antitrust problem. But if we have large patent portfolios and we're wrestling with each other neck and neck, complaining all the time at the high cost of patent litigation to all the regulators, what are in fact we doing? That phone call. In fact, we're doing better than that phone call. Because on that phone call, I don't know about you, but I get tired. I get a stiff neck if I stay on the phone that long. Patent litigation lasts 7 years. Phone, hard to get a lot of data through a phone. I mean, you can push data through a phone line, hard to get a lot of data through a phone line. Several terabytes of data in document discovery, that's high bandwidth. Oh, and by the way, I can tell you whatever I want to tell you on a phone. Why are you going to believe what I said is true? Document discovery, that's in front of federal judges, tried and true. We now have a high-trusted, long-distance, time-unlimited, deep and broad communication channel to coordinate when we are involved in these patent litigations. They can last 20 years, and we're loving it. And if we settle, which we often do, we're doing it in front of the faces of judges. Federal judges, they're going to bless the settlements. So even if the antitrust regulators ask us to rearrange a so-called structural remedy, what we do not have is criminal liability. My shareholders don't pay treble damages, your shareholders don't pay treble damages, and neither of us goes to jail, which we like very much. And oh, by the way, David, he never got a slingshot, and we're Goliath. So we've structured a patent system that helps us deal with each other and that helps us deal with the rest of government, helps us deal with national and international taxing authorities. This is a great game, hyper-proliferation of patents, but patents that don't mean anything to people in the patent system. A different kind of patent. The impact is in a bunch of doctrinal areas. For those who really want to get patent geeky, we can talk about many of these. But I talk about this with my school-age child and classmates and Mysterious Benedict Society. Glasstanium, it's awesome. Clear as glass, strong as titanium. For the adults in the room, this is Julie Louise-Dreyfus and her Saturday Night Live commercial for the brand new Mercedes AA class. It just kind of requires a lot of AA batteries. But you know, the idea, the basic idea, Glasstanium, the basic idea, the battery car, the car that just runs forever and doesn't burn fuel and just takes a battery, like, those are great ideas. The problem is patent law is all about the details, not just the basic idea. So sure, patentees shouldn't get the entire market for just saying, I said Glasstanium first, I call all Glasstanium, even though I still haven't figured out how to make it. But at the same time, the prior art shouldn't avoid patents just because it called Glasstanium first. Actually getting Glasstanium to work, or actually getting a car that will use one small battery and last more than the end of your driveway, yeah, that's actually hard to figure out. So this comes up in 101, and you get really weird rhetoric around 101 because there's now a doctrine called utility and a heightened bar for utility, as though somehow the idea that there's infringement is in itself proof of utility. I don't know who infringes a useless patent. I mean, what are you doing? Useless? Same with the rest of 101 and so-called statutory subject matter. Same with 103 and obviousness. What's worth noticing mostly about obviousness is not that there's some magic way to express it. But if you express it one way, you can get a lot of endogeneity to your language, which becomes circular, which becomes pretty flexible, or you can get more objective. This is the language from the Supreme Court's KSR opinion. If the solution's really predictable, isn't that the prior art predicted the outcome? That's a lot more than glastanium. That's the prior art actually taught the outcome. Or did it not, and we're just concluding that it did? If there's a need in the market, I don't know, there are lots of needs. Just because there's a need doesn't mean a solution is obvious. A finite number, I don't know. Do you know anything that's not finite? I have yet to figure anything out that's not finite. A good reason, known options, within technical grasp, anticipated. For those who are not really up to speed on patent law, it's worth remembering that this doctrine, non-obviousness, you only get to this doctrine in patent law after you've decided that this other doctrine, anticipation, wasn't available. This is totally tautological. This is circular. This is an invitation for flexibility. In the eBay injunctions setting, if you go read the history, turns out that test is not really the test. And in the contract space, it's not clear how you can structure a contract today without facing a range of antitrust limits. And a lot of these cases boil down to this. This is thanks to Google Maps, this is a corner in Washington, D.C., just north of DuPont Circle. There's this enterprise, and this enterprise. On a nice sunny day in Washington, you can find folks in all three of these enterprises basically doing the same thing, sitting, using Wi-Fi, talking or not talking to each other, maybe eating some stuff, maybe drinking some stuff. This is Cove. They rent you the space, they provide the Wi-Fi and food for free. This is a restaurant. They serve meals, but they let you sit there for a little while. This is Starbucks. You buy the coffee, you can sit for a little while, they provide the Wi-Fi for free. Those are just different bundles. I assure you that I don't know which one of those is optimal, but I also assure you, you don't either. And I don't know why we think a rule set should pick one of those. We should let the market pick those and lots of competitors. In so many of these debates, I don't know what's patentable. I bought the stuff, I inherited the stuff, and I just fumbled in to the patented technology. Well, just ask this hypothetical question. I used to be in St. Louis. Right near St. Louis is this. This is Cahokia Mound. At the time this was built, there was a bigger city here than the city of London. About 900 years ago, middle of the United States, back when it was Native America. So let's imagine a hypothetical ancestor of this population, and she digs down into the ground her ancestral home, and she pulls out of the ground stuff, and she arranges the stuff into an arrangement that happens to meet all the elements of someone else's patent claim. What would you call that? Well, any patent lawyer, I hope, concludes that that entire discussion doesn't matter, because if you've got all elements of the claim, it's infringement. Oh no, she didn't copy the patentee, she didn't even know about that. Doesn't matter. There's nothing in patent, that's copyright. Copyright's an awesome body of law, we can study it and talk about it, but they give it away right in the name in copyright law. There's no copyright infringement without copying. Patent, there's no requirement that you copy in order for there to be infringement. So in most of the debates that we see around IoT, around 5G, around standard essential patents, all of this, these are red herrings, because the base case I didn't know and I bought the stuff and I have great title to the stuff, those are all irrelevant to the question of whether that's patent infringement. Now, maybe that means we shouldn't have patent law, or a patent law that has this weird, I guess, allegedly weird feature, which is all elements of the claim is all you need to have infringement, but that is patent law. And there's some benefit to that, and it turns out to work with lots of areas of law. So think about the following argument. That's my jacket. Oh, it's not your jacket. That's Susan's jacket. Hey, maybe that's between me and Susan, but I'm the one who brought it in here. Take it off, give it back to me. The argument that you're not the true owner throughout throughout property law since Roman time has been rejected. That's the rejection of the jus tertii defense, the idea that there's someone else with better rights. These markets, these legal systems work well across culture, across geography, if they reject the argument that we should find the perfect true owner before we enforce a property right. We have, across the last 2,000 years, generally chosen that leads to a bad legal system, not a good one. Or the argument that, hey, I'm just a good faith purchaser for value. I had no idea there was this encumbering property right. I mean, that's a great argument until the encumbrance is registered, like, I don't know, a mortgage or an easement or, I don't know, a patent. I mean, they run this office over across the river in Virginia. That's where we are, the patent office, and they run this great webpage, www.uspto.gov, and for free, you can find the patents. They're registered there, and they're publicly available. And then what about this notion that, well, it's just, I want to be free. I mean, why should I be encumbered by law? Well, I don't know. I mean, law kind of helps us. There are lots of areas of law where we find it's really useful. So I'll move along. What does Judge Rich teach us about patents and patent claims? To focus on the fact that the name of the game is the claim, and that when patent claims get big, they're strong on offense, but they're weak on defense, because they're likely to capture the prior art, or they're likely going to be too vague. And when patent claims get nice and narrow, they're strong on defense. They avoid the prior art, but they probably also avoid a lot of infringement. And where does that get us? Well, where that gets us is a fundamental reality for patents, which is we don't have to try to figure out how close or how far from the core or the gist or the heart of the invention something is. We merely have to determine what are the outer boundaries, is there prior art in the outer boundaries or not, and then is the allegedly infringing product or process in the outer boundaries. So you then get a search when there's infringement for scientific evidence. I want scientific evidence of the market transaction, the willing buyer, the willing seller, the willing licensor, the willing licensee. Well, the search for scientific evidence of a historical fact that we know didn't happen, because we only get to this question in an infringement case after we've adjudicated infringement, we know there wasn't a willing buyer and a willing seller. So that's a search for science fiction, not a search for science. As we think about the way the world is right now, it used to look relatively peaceful, happy little trees, happy little countries. These days, it's looking a little more full of conflict. We see it in trade, and we see it as things seem to rip apart in trade, but we do see lots of reasons for optimism. When you look at how you're going to assemble, whether it's an airplane or a phone, whether it's 5G or 4G, we recognize that the last time we faced a major economic entity with an economy larger than our own, the White House burned. That was Great Britain, now it's China. But what we should not do is react violently. When we see this, it is very attractive for companies to pour money down K Street and ask for favorite treatment. But it's not clear that it really helps. because it's not clear it really lasts. And it's not clear how much it covers. It's pretty unpredictable. And it's so unpredictable that this fella managed to get so much access. This is an actual photo. This is in the White House at the presidential podium with the presidential seal in front of a particular president who was generally not known to really like to share the spotlight. That guy got that kind of access, and everybody thought that meant he was going to get amazing results. This is just a few months later. Hung Tan lost full discretionary review in front of a body, CFIUS, that is generally going to get huge deference from a court, despite that access. So while it's very tempting for big companies to shift the landscape for patent law and other areas of law to suit their needs, I think it's not even in their best interest. What's a better alternative? More predictable patent enforcement along the rules that we know in the patent game, as well as probably false advertising and antitrust. There are basic cases that can be brought, and these cases can be brought without thanking a competitor like China for giving us free stuff, because they're not just giving us free stuff, they're messing with our markets. If you've got an actual setting for a false advertising case or a market manipulation case, you've got a problem, you just don't recognize it yet. What is the problem? Well, full-scale broad coordination, like what happened with LIBOR, that can interfere with all sorts of our markets, and false advertising interferes with our markets, despite our very strong First Amendment preference to let speech be spoken. This is Chuck Heiken, former patent lawyer. He passed away a few years ago, a true gentleman. Chuck brought a false advertising case to the Supreme Court and won. And how did he win? He defeated the First Amendment defense because he pointed out that the falsity was itself so damaging to the market. So, how do you get a lot of this? What you, I think, can notice about this slide is two things happen as we move in this direction. One, the parts of the government become less politically active. Two, the advocates become less hyperbolic in their arguments. Notice what I am not saying. The people who work here are better, than the people who work here. Nor am I saying the lawyers who lawyer here are better than the lawyers who lawyer here. I'm saying that the incentives inside and outside are different, and what are those incentives? These are executive branch agencies. These are agencies that are designed to be responsive to political control. Our executive branch must be. These are designed to be. What should you expect? The sun rises in the morning. They are. Things that are designed to be politically responsive are politically responsive. These are designed to be less. Does that mean they always get it right? No. Does it mean they're actually going to respond differently? Yes. And what about the lawyers appearing before these agencies? When patent validity or antitrust is the only issue on the table, you don't have the Judge Rich, stronger, weaker problem. When all four issues are on the table, validity, infringement, remedies, and antitrust, each lawyer on each side of the case has her own selfish reason to be modest in the presentation of the argument. And instead of getting hyperbolic, you get moderation. What you see is the highly political responsive parts of our government and the European governments respond somewhat similarly, and the less politically responsive parts respond somewhat similarly. But the hyperbolic is the hyperbolic. The hyperbolic leads to the taxi cab driver saying to the spaceman, hey, you're a dummy for stepping out in front of a taxi, and the spaceman says back to the taxi cab driver, double dummy back on you, right? It's just yelling at each other. So what can we do today? We can bring these types of cases, whether they're patent cases with a more predictable system or false advertising or antitrust cases, in front of tribunals that give us the opportunity to build a record that then can be reviewed. And we can separately be building value chains for technology with friendly nations, including not just NATO, including not just Europe, that will allow us to avoid some of the threats, both security threats and economic threats. For the students in the room, I know that this is a lot, and probably what you're worried about is getting a job. And so let me just flag, there are a set of slides and videos on how law students can get out in the market and write their resume and practice their interviews and network and go get jobs. They're available for free on the web. Tom and I are available to chat for students and academic colleagues or in the private sector to help folks solve problems. Thank you all very much for bringing us together. This is a great gathering of great folks. Thank you.